The U.S. Supreme Court heard arguments today in two key cases about how public officials use social media. The cases explore whether two school board members in California and a city manager in Michigan violated the First Amendment by blocking constituents posting criticism on their personal social media pages. The constituents in the cases believe these social media pages were actually operating as an extension of government work. To help us understand the stakes here, we're joined by our Supreme Court analyst, Marcia Coyle. It's always good to see you.
Good to see you, Jeff.
So, Marcia, you were in the courtroom for the, 3 hours of proceedings?
3 long hours.
So what's the question that the justices were considering today in both arguments?
Well, the challenge here for the justices is to determine how can you know when a public official is speaking in his or her official capacity or personal capacity on their personal web pages. And the distinction is important because if it's in the official capacity, what we call a state actor, then the First Amendment kicks in. And that public official could be held liable for violating the rights of someone who may have been blocked.
So in the one case, there's James Freed. He's the city manager in Port Huron, Michigan. He has this personal Facebook page where he mostly posted about his family, but he also, during the pandemic, would post about COVID and other city-related matters. And he blocked from his Facebook page a man named Kevin Linke after Linke posted criticism of the ways in which Freed was handling the pandemic. And so our team spoke with both men about how they see the case. Here's what they had to say.
School teachers, police officers, firefighters, school custodians, like my grandfather was, can't go home and talk about what happened at work. Just think of the chilling effect that would have on those people. I have a right to free speech. In the middle of a COVID pandemic, I have a right to communicate with my friends and family on what's going on in our lives and what's going on with our community.
He can say that this was his personal page. I don't necessarily disagree with that. The issue is that when he started blurring the lines and started putting out policy directives that couldn't be found anywhere else, he then created a public forum, and therefore the protection of the First Amendment kicked in. And by, blocking stuff he didn't like or stuff that was critical of him, we felt that was just, he was trying to silence us.
So tell us more about how the justices interpreted those two arguments.
I'll tell you, Jeff, during the 3 hours, there were lots of hypotheticals about what kind of posts on a social media page could constitute, either private speech or official speech. There was even mention of Donald Trump, and even Taylor Swift entered the conversation.
Because Donald Trump, when he was president, he blocked people.
Absolutely, on Twitter, which is now known as X. But his case ultimately was mooted out because he was no longer president. But what was happening in the arguments was the lawyers were trying to offer the justices a variety of tests for how to make this distinction between the two. And the public officials really want a clearly defined, kind of rigid test that says, basically, if you are fulfilling a duty on your personal web page or you are demonstrating authority, then you are state action, and the First Amendment will apply. And the individuals who were blocked, their lawyers were telling the court, no, that's too narrow a test, and we think you need a broader test. One lawyer described it as, are you doing your job test, which looks at the content of the page, the appearance of the page, and the function that the public official serves. The justices had some qualms about both tests. One was considered a little too narrow and would chill speech. The other was considered too broad. And I think ultimately Justice Kagan sort of hit the nail on the head on what the justices were facing. She said what makes these cases hard is that there are First Amendment interests on both sides. Public officials have every right to engage in the kind of speech you and I do, to talk about their jobs, to talk about job with someone in the grocery store, talk about family, friends, pets, and an individual has a right to be able to access information that government information that may be important to their lives, as well as to share in the conversation on that page with other commenters. So I think they're struggling here not only with what's the right test, but also what is a social media page or account. There was a comment by Chief Justice Roberts at one point who said, basically, what is it? Is it a gathering of protons or what? Is this really property? So it's a dilemma for them, and they've got opportunities. I could not tell which way they were going to go on this at all.
And we should say, these two cases, these are not the only social media cases coming before the court this term. It's such a sign of the times that social media is so big in this term.
Lots of issues. They have 3 more cases that they're going to be looking at, probably hearing arguments in the new year. The cases today are significant in their own right as to what they will do in terms of speech. When you put them together with the other 3 cases, it becomes a huge term for not only social media, but also for the First Amendment.
Marcia Coyle, I have to say I'd never block you on social media.
Thanks, Jeff.
Thanks so much for your insight and analysis.
Take care.